with due consent of the other side, I beg to mention for adjournment.
But the item number 4, Lordship fixed on 24th because the council for the standing council for the housing board has a telephonic me that he is casting his vote in Hemaji.
Item 4,
Item 4, let it be on 24th, my lord.
24.
24,
Item 4, adjourn request.
24.
It's on 24. Wait. Yes.
Next to the lordship. In item number 3, my lord, I filed a reply to the additional affidavit filed by the respondent of 4. The record, the affidavit may be called on record. My lord, and
No,
it may
item
be
4, I am
taken
applying
after
for the
submitting.
PTC, my lord.
You
Item-
have objection.
Item-
Then I will come and,
Any other day, my lord, because he's filing his.
Monday, my lord, I have filed
When did you file it? Today.
They have not filed it.
today because yesterday they could not be filed to file a subda copy, my lord.
Let it be in any other day, my
Yesterday it
lord.
was- Tell it on
Item-
Monday, my lord.
Item 3, it is submitted that an additional, you filed what? Affidavit in reply.
Affidavit in reply in additional affidavit.
And in the additional affidavit filed by the respondent, how the same is not available in case record. Registry to trace out the same and connect it to the case record and list the matter again on, let it be on 8th.
Lordship.
This week, next week can be little bit below, because my
Next
lord,
week.
my lord, will come as motion only. 4th or 5th,
Yeah, 4th, 5th is not possible. We can have it
because
on,
it will be for disposal, so many
we
times.
can have it on 3rd,
Third, Lordship.
3rd,
Third, May. Problem.
3rd May.
Much obliged.
May please, Your Honor. My lord, item 7, my lord, to 16. This is a series, my lord, relating to Ascot Bank. Now, these cases, my lord, are part heard before my lord Justice A.D. Chaudhary, my lord. So, my lord, I leave it.
Wrongly listed.
My lord. It should next week, my lord, before the appropriate bench.
Take up and confirm. Item 7.
Yeah.
7 to
7 to 16, my lord.
uttered before any other page. Right. All right, we'll pass orders. It's submitted by the learned counsel. Yes. Okay, it's submitted that item 7 to
16, my lord.
7 to 16 have been kept as parted by coordinate bench within bracket Justice A.D. Chaudhary. Accordingly, registry to verify and place it before the appropriate bench. Yes.
Obliged.
My lord, I beg to mention item number 60, my lord, supplementary list matter. In this case, my lord, the petitioner already got the relief, my lord. So matter had become infectious.
Item 60, it is submitted by Mr. S. Hawk, learned counsel for the petitioner, that the relief sought for by the writ petitioner has been redressed. Accordingly, the writ petition
Closed.
is disposed of as not pressed.
My lord.
Interim orders, if any, stands vacated.
Obliged.
May I plead the lordship, my lord, I beg to mention item number 43, my lord. My lord, I am appearing for the health department. I have taken consent of the petitioner. We have not received the inspection, so some time may be granted, my lord. Petitioner is also here, my lord.
That you make a mention when the matter is called up. Why are you making a mention at 10:30? 10:30 is it? Who's for the respondent?
I am for the respondent.
Who's for the petitioner?
He is for the petitioner.
Yes, any objection? Item 43
My lord.
stands adjourned for 4 weeks. At the request of Mr. D.P. Bora, Standing Counsel Health,
Obliged, my lord.
Mr. R. Sinha, learned counsel appeals for it.
I beg to mention for listing on writ petition, your lordship. It's cancel matter, your lord.
Whole matter. When was it last listed?
My lord, last one, 10/1/24. My lord, respondent has appeared, my lord. Second one has appeared. Petitioner is the first one.
You list it on week beginning from 6th May. 6th May.
6 May.
6th May.
May I please, your lordship, my lord, with regard to item number 24, my lord, I'll pay for an adjournment.
24.
Yes, my lord.
24 at the request of learned counsel for
For the petitioner, my lord.
the petitioner, matter stands adjourned for 3 weeks.
Obliged, my lord.
I beg to mention for list of and pending matter.
Pending matter for,
Petitioner is not getting salary and
for admission.
for admission. Notice or
Sixth
Oblige.
of May.
I beg to mention item number 46. My senior is out of station, so kindly adjourn the matter. to the-
Item 46 is connected to 45. 46 and 45 are connected. So 46 can be adjourned on its own. You are appearing on whose behalf?
Respondent.
Respondents.
Respondent.
Ah, item 46, that,
46 and 45 connected. 45 ballot by bench is there.
who is your senior? Who is it?
B-Deca.
Huh?
B-Deca.
Difficult to fix dates like this, 45, 46. Forty-five, 46 at the request of the learned counsel for the respondents. Matters then adjourned to 16 May.
16.
Counsel for the petitioner does not object. Prayer may.
May I please report? Now, with regard to item number 57, last item of the regular.
Yes.
That government has not filed affidavit matter. And otherwise, await for service report with regard to respondent number 7 of
Item number,
57.
your
And for
for,
the petitioner,
your for the,
petitioner.
what is your prayer?
That may pay for after 10 days. My friend,
Item 57 be listed after 2 weeks.
well,
The
interim
request
order
of the
is-
learned counsel for the petition.
interim order is there.
Interim order, if any, will continue until further order.
May I please your lordship, I beg to mention item number 33. The petitioner has already received the relief. So matter may
Item?
be closed. 33.
33. It is submitted on behalf of the writ petitioner by your name,
K. Burma.
MSK Burman, counsel for the petitioner.
Yes.
That the writ petitioner has already, the writ petitioner's grievance has been redressed, and therefore it has not been press the writ petitioner any further, accordingly dismissed as not pressed. Interim order, if any, stands vacated.
Lordship, I am for respondent number 8 for accountant
Mr.
general,
Mr.
Harborough,
Harborough for respondent 8,
accountant general.
accountant general, okay.
May
Right.
it please your lordship. Lordship, I beg for mentioning item number 54.
Hmm.
As the learned counsel for the review petitioner is unable to be present today due to personal difficulty.
Item 54 after 3 weeks, at the request of learned counsel for the petition.
May I please your
Okay.
lordship? Lordship, I beg to mention item number 25. Mr. Acharya is out of station today. The matter will be taken up next week, your lordship.
Item 25 at the request of learned counsel for the petitioner after 2 weeks.
Much obliged, your lordship.
May I please, my lord, I am praying for listing of a pension matter.
Pension matter.
Mal-
On 6th May,
Oblige.
you want to withdraw it?
Yes.
It is submitted by the learned counsel for the petitioner that on instruction that the petitioner does not wish to press the petition any further. Accordingly, the petition stands dismissed on withdrawal. Interim order, if any, stands vacated. Pending ayes are also dismissed. Yes.
May I please, Lord. My lord, in this case, notice of motion has already been issued, my lord, by the order dated 8/1/24, my lord.
Lord, here I have received instruction, my lord. As per instruction, my lord, petitioner and petitioner sisters claiming that benefit separately, my lord. And there is a civil case is pending before Lakhimpur, Muntip number 2.
As to who will get the benefit.
Yes.
There's a fight between brothers and sisters.
Yes.
You are for the brother.
Yes, my lord.
So?
Let them file affidavit, my lord.
Why should they file? Why should we wait for filing?
Because, my lord, Mr. Yan Bora is the, my lord, engaged counsel, my lord. I have
On his instruction, my lord, I have appeared today.
All right, you get the details of the case record of the matters pending before the civil court.
My,
List on 6th.
my lord.
6th of, no, not on 6th. On 10th of April, sorry, May. 10th of May.
Okay.
Matter stands adjourned to 10th of May as it is submitted to the council petitioner. Mr. N. Bora is out of station.
My lord.
Meanwhile, Mr. G. Pegu, Learned Counsel, appearing for the elementary, submits that both brothers and sisters are separately claiming the what dues? GPF,
My lord,
Retirement
service benefits, my lord.
service benefits and retirement benefits of late Jiten Borwa. And in that context, civil civil suit is pending between the parties before the competent court. In which district?
Lakhimpur.
In the district of Lakhimpur.
Munship number 2, not Lakhimpur
All
problem.
right. Accordingly, the respondent counsel will place the relevant instructions before the court on the next date fixed. Mr. P. Sharma appears for accountant general. Based on 10. What date did we give? 10.
10th of May, my lord.
10th of
All right.
May it please your lordship. Lordship, the respondent authorities have filed their objection. So kindly 4 weeks time may be granted to us to file our affidavit in reply.
learned counsel for the petitioner submit praise for 4 weeks time to file her objection. Prayer allowed. Please stop the court.
Right, lordship.
Doctor, senior is on late after some time.
Right up to something. Hold on. Hold on. Yes.
I thought pertains to my lord, compensation of family pension, my lord. The director of pension issued the PPO, my lord, kindly say page 30.
Hmm.
Stating, my lord, monthly pension, my lord, stated 0, my lord. Page 30, my lord.
Yes.
The petitioner is the unmarried dependent daughter, my lord. In pursuance of the notification, my lord, she is entitled to receive that pension, my lord.
He is unmarried.
Unmarried, my lord. And subsequently, my
Not
lord,
employed. Not employed.
non-employed. Subsequently, my lord, kindly see page 33, my lord. The inspector of school again forwarded the proposal to the director of pension, my lord. Page 33.
Hmm.
But time is pending before the director, my lord.
Yes, yes. Consider and dispose of. Who's appearing for the director of pension?
Government, my lord.
Lordship.
You get instructions. What is the status?
Lordship, I need to seek instruction, lordship.
This was on 27/7.
7, my lord.
Lordship, July.
It is submitted by learned counsel for the petitioner that the petitioner is the unmarried dependent daughter of the government servant late Kulyani Ray, who was serving as assistant teacher in Disney Girls High School, Disney. Stop. Pursuant to her demise, the petitioner being the unmarried dependent daughter, he is entitled to be granted the benefit of family pension. And accordingly, necessary papers have been necessary proposals were placed before the competent board, competent authority. So, Mr. The counsel for the petitioner submits that by communication dated 27/7/2023, the inspector of schools, Chirang District Circle, has communicated with the director of pension, forwarding all relevant documents for release of compassionate family pension in favor of the petitioner. However, the same has not yet been. However, no favorable order as yet has been issued in favor of the petitioner. Being agreed the present writ petition. MS
A Talukder.
A. Talukder, learned common advocate, will obtain instructions with regard to the status of the proposal forwarded by the inspector of school, Chirang District Circle, to the director of pension. ID communication dated 27/7/2023 within bracket and equal 12 the writ petition. Matter being listed on 6 or 10. Huh?
15, Lordship.
15, right, 15,
Biplab.
15.
Obliged.
Extra copies be furnished in a period of 1 week from today to the learned government advocate to enable her to complete the instruction. MSD Mutahari appears for respondent 1, Mr. Borpudari for respondent
3 and 8, my lord.
3 and 8,
Lordship, I'm for 2 and 4, Lordship.
2 and 4. So extra copies be furnished to all these that you know.
It was, I'm extremely sorry, my lord. There I was having item number 1. Just I finished. Item number 10 is there, my lord.
Huh?
Item number 10 is here. I have got item number 10, but I was in footnote 26 for item number 1. That has been judgment passed. on.
Item
Lordship,
number
I can-
10.
Yes, my lord.
Item number 10 is a part of the series, which is stated to be parted before coordinate bench, therefore,
No. My lord, item number 10 is independent. Niloy Datta.
no, I think you're wrong. 10 in the list is a contempt matter. You check the list.
Okay,
Lordship. Lordship, my senior is on leaks. Can this matter be taken after some time?
You are for the,
Health department. Health department.
where is the petitioner? We are passing it over for the time being.
wait, please, Your Lordship.
You want directions to 5 and 6. How
Lordship.
can we give directions to 5 and 6?
Lordship, direction may be given to the deputy commissioner or Lordship B or D or.
Yes, who's there? Why the order has not been complied with?
I have to take instruction now.
Heard learned counsel for parties petitioner is aggrieved by non-compliance of which order?
Lordship, order dated
Page number?
Note 7.
page number, Lordship, one is annexure 3, page number 17, and another is annexure 4, page number 18. Specific instruction is 2-4, Lordship, annexure 4.
Annexure 4.
Yes.
That pursuant to orders passed, the petitioner was reverted back to his original place of posting at Ali Pukuri ME School. He was reverted as what? As headmaster.
Lordship,
As headmaster.
Lordship,
However, he was not allowed to take over charge in terms of the order dated 21/3/2024, passed by the District Commissioner Morrigaon reverting the petitioner. So, aggrieved the present petitioner before this. Mr. G. Pegu, learned standing counsel, education will obtain, elementary education will obtain required instruction. Let the instructions be placed before the court. On
Deputy Commissioner,
on first,
It may be little earlier, Lordship, petitioner.
10th of May, madam. After the election.
you have to get instructions. Why is he not allowed to join? That's all.
Yes, Lordship. Very small instruction, Lordship, it can be come over.
24th.
Lordship.
Have it on 24th.
Yes.
April. Extra copies be furnished within the course of the day.
Lord.
List on 24th. Who else appears? MS M. Bhattacharya for respondent 2, DC.
Yes, Lord.
It is the DC who has passed the order.
Yes, Lordship.
So get the instructions why his order has not been allowed to be complied with by the private respondent. Yes. Yes.
Wait, please, Your Lordship. This application is for improvement of Director of Secondary Education as well as the Secretary, Your Lordship. Because the statement was made before this honorable court that some of the petitioners' schools have merged with the secondary educations. In that view of the matter, these two persons have been impeded, Your Lordship.
Sorry. Huh?
Your Lordship, this IA has been filed for improvement of Secretary Secondary Education as well as the Director of Secondary Education. Because the statement was made before this honorable court that some of the petitioners' schools have merged with the high school. So therefore, the instruction can be provided by the secondary, Department of Secondary Education.
Any objections, respondents? Education?
Same.
Any objections?
No, Your Lordship.
Heard, learned counsel for parties. This IA has been filed for improvement of the
Secretary of Secondary Education and Director of Secondary Education.
Secretary and Director of Secondary Education, respondents in WPC 539 of 2023. Stop. The said opposite parties are sought to be implemented as parties, as it is submitted that school has been merged.
Merged. Some of the petitioners, Your Lordship, petitioner number, not all
Some
the,
of the petitioners who are working in their the schools in which the petitioners have been working have got merged in the meantime with
the high school level.
the high school. And accordingly, the opposite parties sought to be implemented as parties are necessary and proper parties for
Respondent number 5 and 6.
proper identification of the matter. Where notice in the matter was issued on 12/2/2024. Did you take any steps pursuant to issue notice?
Your Lordship, I have submitted a copy. I'll submit the extra copies of along with the memo of the parties to the council for the
No
secondary.
objection has been filed with the opposite party respondent. Accordingly, these IA stands allowed. The opposite parties number
5 and 6, Your Lordship.
5 and 6 are arrayed as respondents number 5 and 6
Yes,
in WPC 539 of 2023. The petitioner council will file amended post title in the same petition before the registry within a period of 2 weeks from today. I accordingly stand disposed of. In the main writ petition, you write in view of the order passed in I so and so are arrayed as respondents 5 and 6 in the writ petition, and petitioner to file amended post title
Your Lordship, memo of
before
party
the
settlement.
before the registry. Amended post title
Yes, sir.
before the registry. Stop. Meanwhile, the newly arrayed respondents are given liberty to complete their instructions and file necessary affidavit in the meantime. So, Mr. P. Sharma appears for Accountant General, both in the writ petition as well as in the I. List after 3 weeks.
Your Lordship, in the main case, there was a direction from this honorable court that as regard respondent number 4 and 9, they have said that they have processed it. So there was a direction to take the instruction on 18/12/2023.
Day means who has processed it?
It was said that Miss S. Kumar Lani, Standing Counsel, Elementary Education
We'll
Department.
see on the next date. First, you complete this process.
If an extra copy could be
Extra
provided.
I'll give.
copies of what extra copy you want?
So the earlier set of council is retirement and
I'll give it, you know.
Extra copies, fresh copies of petitions will be served on the respondent councils.
Give your Lordship.
Okay. Please, your lordship, I have to take instruction, my lord, some one week time may be given to take instruction. My lord.
No objection, Lordship.
Prayer for further time made by the CTCM. Are raised by accordingly managed for 3 weeks.
Master of law.
may adjourn this matter for today, Lord. May
Right.
come next week, Lord.
Right.
Dr. T. Taluka is out of state.
It is submitted that counsel for the petitioner
Petitioner.
is out of station. Therefore, adjournment is sought for on behalf of the council. Accordingly, matters stand adjourned for 2 weeks.
May I please, your lordship? My lord, actually, what happens in this case, petitioner is a retired grade 3 employee of Motor Accident Claims Tribunal, Nalbari, my lord. My lord, while retiring from service, 60 altogether 69,302 rupees detected as overdrawn amount. So we are praying for a waiver of the said amount, like number one. And number two is, my lord, as per modified assured career progression scheme, he is entitled to be considered for financial upgradation. That two prayer is there. My learned friend is appearing for.
Milord, if my senior friend agrees, Milord, it can be disposed of because so far as the amount of recovery is concerned, we have already written to the Commissioner and Secretary Government of Assam Pension and Public Grievance Department for waiver of that recovery amount. And so far as MSCP is concerned, Milord, we have there is a communication by which we have stated that he is entitled for MSCP. But the problem is that composition of the committee to consider this release of MSCP, there was some problem with that committee. Perhaps that was a situation in 19. Perhaps that has already been resolved. If the petition is disposed of, directing the respondents to consider release of the MSCP.
We set up the committee.
my lord, the committee was set up by the government of Assam. So, my lord, there was a communication. I just take your lordships. Because lordship will kindly take up the additional affidavit filed on, my lord, 10/11/23 by the petitioner.
Yes, yes, my lord.
He has annexed this
14,
document.
page
my lord.
14, 49. Page 49, my lord.
Yes,
First
Oh.
is, my lord, lordship may kindly see.
49
page
or
46.
69,
Page 46, my lord, running page 46, my lord,
46.
46, Annexure 13.
Yes.
Annexure 12, your lordship will see first. This is the communication issued by the presiding officer.
No, this is to the presiding officer.
To the
Annexure
presiding.
12.
To the presiding officer,
Lordship is, no,
by the senior accounts officer.
Annexure 12, page 45.
second.
Yes.
Previous annexure, my lord. Annexure 12, sorry, my lord, annexure 14, communication dated 4/4/2019. Lordship is referring to the additional affidavit.
I don't know, it's come. 4/4.
4/4, yes, my lord.
This is from presiding officer.
Yes, from presiding officer to Registrar General.
No,
Lordship
no,
will
this is to commissioner and secretary.
Waiver of
4/4.
waiver from কোট আছিল? কি
waiver from আপনি 40
There is another 4/4.
Yes, my lord. There is a
Annexure 14.
4/4/19
Hmm.
dated. So this was, my lord,
To the
sir,
register.
with, yes, to register, sir, with reference to the subject cited above, I have honor to inform you that one of the employees of MSCT Nalbari, namely so-and-so, is eligible for grant of financial arbitration by way of ACP by virtue of the aforesaid notification and the reference. It may be mentioned here in that Sri so-and-so joined LDA on so-and-so in the establishment of district and session judge Nalbari. Said Mohendra Das completed 30 years of service on so-and-so. He is due to retire on so-and-so. In the meantime, during his entire service period of more than 30 years, said Mohendra Das got promoted only once to the post of UDA on so-and-so. There is no departmental or criminal case pending or contemplated against Sri so-and-so. By virtue of the beneficial provision of the aforesaid two notification dated so-and-so, in order to consider the case of Mohendra Das regarding entitlement to the benefit of two increments by way of MECP, if any, a screening committee is to be constituted comprising of the head of office, appointing authority as chairman and two other members, one of which shall be from the finance service or account service, where no officer from finance service is available. As the establishment of MSCT Nalbari does not have any accountant or member of finance account service, I therefore kindly request you to look into the matter and be pleased to direct us regarding composition of the screening committee. Pursuant to that, my lord, and next page, Register Vigilance has written this communication to the presiding officer. With reference to the subject cited above, I am directed to inform you that by this letter number so-and-so, the government of Assam was moved to modify the government notification number so-and-so, so that the screening committee for grant of modified career progression scheme to the employees of district judiciary may be constituted comprising the appointing authority as chairperson and two other officers as nominated by the appointing authority as members. You are therefore requested to take necessary action accordingly. So perhaps this committee has been already, my lord, formed.
So perhaps it
I am that
get the
instruction.
instruction
That's true, my lord. That's
constituted by
government,
or by the presiding officer.
no, by the government. The formation of the committee, because the government was moved to modify the notification so that screening committee. But there is no dispute with regard to the fact that he is entitled
You get the instructions.
regarding the.
What is the status of the committee?
Yes, ma'am.
How much time do you require?
My lord, 10 days time, I'll get the instruction.
Heard when it comes. I submitted that. That in principle, a decision has already been taken that the excess amount sought to be deducted from his pensionary benefit is not to be proceeded with by the appropriate authority. And also, the benefits that the petitioner claims to be entitled under the MSCPS are also to be decided by the committee constituted for such purpose, and thereupon the benefits can be released. So, Mr. H. Das, Standing Counsel, appearing to the High Court, Guwahati High Court, submits that he be granted a short date to complete his instructions as to whether the committee required to be constituted for consideration of the MSAPS benefits to the writ petitioner has been constituted, and as to whether the case of the petitioner has in the meantime been considered. So, such prayer is not objected to by Mr. J. Sharma, Learned Counsel Petitioner. Accordingly, matters stand referred to be listed again on 15th of May.
Fine, ma'am.
15 May.
Fine. Good.
Mr. S.K. Medi for. Somebody mentioned you are out of station in the morning.
No, well,
Huh?
no, no.
DP.
Mr. S.K. Medi for CTC.
Polite.
I don't know. I may be mistaken, but I have a feeling that somebody made a mistake. Huh?
I leave.
So I'm sorry, it is Mr. B. Deka, not you.
May it please the Lordship.
Lo- Lordship, my senior has legs on a different matter right now. Kindly the matter may be passed.
Who is your senior?
MK Das, Your Lordship.
M.K. Das. Yes, Mr. Bora, what do you say?
Well, a very short question of is involved regarding this. If your Lordship has heard the matter earlier, that I have been arrested, and thereafter, well, the proceeding has started, the criminal proceedings, and I have been acquitted, my lord. During this trial, my lord, I got superannuation, and during that, once I have been acquitted from the all charges, my lord, there is no departmental proceedings also against me. Now I have filed an application for revoke the suspension and to pay the entire salary allowances, my lord, what I'm entitled to, my lord. That has not been rejected, and thereafter an appeal has been filed, and an appeal say that the 95% of pay and allowances has been given, and there's two grounds which has been taken on an affidavit, their affidavit, saying that he has not been honorably acquitted. That is number one. And number two, as he was, although he has been acquitted, my lord, he is entitled to get only 95% of pay and allowance. So that is the only question. When DP was not there, my lord. My lord,
Take it up after a while.
my lord.
Lordship. Much obliged.
May I please, your Lordship? Lordship, I am appearing on behalf of A. Alam. If your Lordship allows me, I may be allowed to place the case, my Lord.
So if you are a part of the council, you can. Are you a council?
No, no, my Lord. That's why liberty may be given. If your
No,
Lordship,
liberty I can't give you. It has to be granted by the petitioner. Unless you are a senior counsel, we can grant you a
my
liberty.
then the matter may be passed over because he is
Matter
outside.
passed over at the request of Mr. A. Alam. But your name,
Not named, my Lord.
name does not appear.
My Lord.
Matter is passed over at the request made on behalf of Mr. A. Alam,
A date may be fixed, my Lord.
Learned Counsel. Based on
My Lord.
13
Much obliged.
MS M. Bhattacharya appears for the government. Yes. Who appears for the and appears NJ Katoni appears for the respondent. Obliged. Yes,
I'm
Mr.
sorry, my lord, I was.
Well, yes, your lordship, my senior is on legs.
Oh.
Important then.
Yes. Who is your senior?
MG Bora.
Please call her.
In fact, on the
This
last.
is for
occasion-
transfer.
Yes.
So you have to find a way.
Yes, my lord, that is what your lordship observed on the last date. The respondents have not filed any affidavit as yet. But then to see some alternative, my lord, there are several posts in Guwahati, in and around Guwahati. But then the imprint order of transfer was in respect of 220 persons. And right at this moment, my lord, there is all these posts are filled up by transfer. Except, my lord, this fee that your lordship has given, the petitioner, except that, my lord, those are, my lord, filled up. But then there are at least, my lord, 4 posts in Guwahati. And
So see that we are not getting into whether this post, that post.
yes,
The question of you are expressing difficulty in respect of your daughter.
yes,
But whether you are the primary caregiver,
yes.
do you have any
In fact, my lord, in the writ
documents
petition,
to that effect?
I have stated, my lord, in fact, in the
There is an
representation,
interim order.
my lord,
There is an interim.
there is an interim.
Take it up next week then.
Let them file an affidavit, my lord. Let them also say whether they have considered it or not.
Third. Have you represented before the authority?
Representation there, my lord, there are 2 representations. Those have also not been disposed of. And my lord, the verbal submission was that, my lord, the 2018 notification they are not following. Let that come on record, my lord. Can they really say that we are not following that way?
Matter be listed next week. Maybe the respondent of the right. In order faster.
Obliged.
On 6. 6th of May.
May please, Lord. Lordship, in this case, I want 2 weeks time to open inspection, Lordship.
Yes.
In the earlier occasion, wala dishonorable directed to file affidavit, madam. SG and irrigation department. 14th, kindly there is order dated 14th.
I am for accountant.
You are for
AG, your Lordship.
accountant. You are given 2 weeks time.
Lordship, I understand, your Lordship. Earlier, A. Hassan was dealing with this case, your Lordship. We have been recently engaged in this case, your Lordship. So we
What
have
happened
written to them.
What happened to the earlier council? What happened to the earlier council?
Earlier council, he is no more in the AG, your Lordship.
He is no more in the panel.
And he is no more in the panel, your Lordship. I'm on behalf of Siburo, your Lordship. After 2 weeks, your Lordship, I will come with you.
What is your case? You are working as a master role.
Master role worker, malad, denied malad pension due to malad non-completion of qualifying service of 20 years, malad, after deduction of 6 years. It is a covered case, malad, Sanjita Roy. And another point, malad, recovery part, malad.
2 issues are involved here.
Overstep, malad, allowance already recovered from the lease salary. Kindly see page 22, malad. Page 22. An amount of rupees only is released to the person concerned after deducting a sum of rupees 2,31,000.
This is a covered.
Lordship, 2 issues are involved, Lordship. I will come with the instruction, your Lordship, next day. We have written.
What instruction? The covered. These are covered matters.
Lordship, I
The orders
understand.
are already there. What instructions you want? Right.
The recovery part,
One final opportunity.
Lordship,
Get your instructions
Lordship.
to see whether there is any contribution on the part of the petitioner for overstay the matter.
Get
At
my
the request of the counsel for recovery. Third of May.
Oblige, Lordship.
Learned counsel is here.
May I please lordship. Finally, see the last quarter lordship. There's a, they took time lordship to file every lordship. I have not got any.
My lord, I have received an instruction from this, my lord, the department, my lord, they need further 2 weeks time, my lord. It's an old matter, my lord, so it's,
Weeks
it's
time
an,
for what?
to give us the parawise comment, my lord.
What instructions they give?
That is the instruction, my lord, that they need further some time, my lord. And because of, my lord, this election, entry election, my lord, most of the people are engaged in election. That's the problem. We are working in a very thin ice, my lord, situation, my lord. So, my lord,
No,
I will ensure that
that submission I would have accepted if before or after elections your instructions were very prompt.
no, my lord, no, my lord. My lord, I ensure that, my lord,
This is the general submission that's here.
my lord, I'm giving undertaking, my lord. In 3 weeks' time, I will file affidavit, my lord, definite, my lord. My lord.
What is the petitioner doing?
Petitioner lordship, no, they are just sons lordship. The petitioner lordship, he was lordship, second assistant lordship.
No, son, but what are they doing? Nothing.
They are student lordship, the petitioner. Petitioner is a student.
Student.
Yes, lord. Student. In video lordship, the mother also fight lordship, mother also expert lordship. Now we are student lordship, we have to come lordship.
He was working as what? Section assistant.
Yes, lordship, definitely.
They are entitled to pension.
Yes, lordship, second assistant and.
They are entitled to pension.
My lord,
They are entitled to pension.
no, my lord. Here the facts, that is what, my lord, I have to ascertain, my lord. My lord, this is the document, my lord, that I have received from the department, my lord. It's yet to come, my lord. That is the factual aspect that has to be seen, my lord. Whether he was working in a sanction post. If so, my lord, then why he was not regularized, my lord? These are the aspects, my lord.
Okay, at the request of Mr. Hardcore, matter deferred. You're Mr. Hawk.
Yes, lord.
It's after 3 weeks. There are some factual issues to be verified.
Yes, lordship, let them file it. No matter.
Because, my lord,
What date may be given lordship.
it says that, the instruction says that, my lord,
Yes, lordship.
because of this,
Listed again on 20 of May.
I am for a TV.
Sir?
But
Aria appearing for 8. Yes, matter will be listed next week.
Lordship may kindly fix a date before 6 because there is interim order is operating. Then we have urgency. I have already placed the instruction that we are not following that OM. So my lord may 2 days date fixed for the petitioner to get instruction.
It on record.
The Lordship may kindly fix the
On record.
Lordship may kindly fix the matter on 2nd of May.
What?
The interim order is operating, Lordship. We have
Maybe,
urgency.
but you file your counter. When are you filing it?
We'll file before that, my lord.
So if you file before that, they will need some time to respond to that also. You can trust it about them.
So on like then my lord has directed the petitioner council to take instruction whether is there any vacancy in nearby Kamrup Metro, because we are not adopting the OM as my lord has directed me to take the instruction
No,
of
you
it.
may not be, but then you must also consider this hardship.
Lordship, I will bring it on record, my lord.
Tell us what is your stand.
Lordship.
You cannot be oblivious to this. There is a actually these things are not correct, then you must, then you can certainly insist. But then
understand, my lord.
there will be people like them having these
Yes,
difficulties.
yes, my lord. I understand, my lord.
And
But
you, the state also has come out with an act
yes,
caring
my
for
lord.
the elder, caregivers. Then
Yes, my lord. Then I will file the affidavit on 2nd. In the meantime, they may file the reply. My lord may take up the matter on 6th for final deposit.
we have given on 6th only.
No, my lord.
6th. You file the affidavit.
Before that, I will file.
Yes.
God bless you.
May I please? Lord?
Yes.
My lord, in this case, my lord, earlier, my lord, 3 times the respondent office took time to file affidavit, but yet not filed, my lord. What can I do? In this case, my lord, petitioners, my lord, prayer for release the stipendary grant in 8 week effect from, my lord, May 1997 to 2013, my lord. As they were working as a assistant teacher, my lord. My lord, they have been appointed as stipendary, my lord, kindly see page 37 appointment letter, my lord. Per month, my lord, 900 PM with effect from.
Where is the impugned order?
My lord, yes, my lord, impugned order, my lord, page, my lord, 170, my lord, 170, my lord. Earlier 2 round litigation, my lord, this is third time litigation, my lord.
Yes. PTC?
Implemented passed by the state government, but they have declined the. What's the find that particular order 170, 121?
There is a delay of 14 years.
No, in fact, there
But-
we have to go the court after
But
27 years.
number two does not seem to be properly, does not seem to be a proper condition. Setting aside of the Act of 2011, the rights were protected in the review order.
No,
My lord,
order
in
is,
fact, my lord,
order
there-
is illegible, my lord, that particular order, my lord. Even have.
In my copy, it is
I'll
legible.
copy it. I'll copy it.
So pleadings are complete.
No, my lord.
My lord, still, my lord, they did
You
not.
file affidavit.
Yes, my lord.
File your affidavit.
My lord, last chance we begin, my already third
No
time.
last turn, no last turn. This is a matter of actual issues. We'll have to hear it. We'll issue rule then. Let them file their affidavits.
That's true, my lord, but
Okay.
3 times already.
Heard
Madam.
council should participate. Rule. pleadings be completed in the meantime. Matter be listed thereafter for hearing. In the month of June, we'll have it in the month of June, on a date to be fixed by the registry. You file your affidavit here.
Yes. My lord, BTC as well as my lord.
Yes, both,
Both, yes, my lord.
both the respondent.
Obliged, my lord.
Apologize, Your Lordship.
Yes.
My lord, the petitioner before your lordship was arrested on 7/6/2016, my lord. And thereafter he has been put behind the bar. And as he's 48 years of hours in the custody, my lord. So he has been suspended.
Now you are placed under suspension
My lord, yes, that has not been revoked, my lord.
till date.
Till date, because
You-
I
you
got
have retired?
superannuation.
You have retired
Retired in 2018, my lord. The judgment has been pronounced in,
while you were under suspension.
yes, my lord. I have filed an application for revoke of my suspension that has not been considered, my lord. Now your lordship will find my prayer is very limited. My lord. One, to revoke my suspension, to give me the entire whatever I am entitled for, I have to get. And my lord, the other allowances which I am entitled to. Now, your lordship will find their affidavit, my lord, what they have stated, my lord. Now, there are two grounds they have been stated, my lord. If your lordship kindly see, there is page, it started from page 57. When my prayer was not considered, my lord, I have filed an appeal, my lord, before the GM, my lord. CGM, my lord, Chief General Managers. Now, your lordship will, my lord, kindly see the page 58, the relevant paragraph, my lord. Relevant paragraph, my lord. Now they have said that they have revoked the suspension. It is not there, my lord, what they have stated, my lord. 58, kindly see. Whereas the appellate authority CMD, after consideration of facts, circumstances will be decided as under, it is observed that Sri Lochan, ex-DGM, civil was caught red-handed while alleging taking bribe by CBI so-and-so. He was taken into the custody by the CBI immediately. He was subsequently released on bail by the court on so-and-so. His charges has been filed on so-and-so under various sections of the Prevention of Corruption Act for the demanding of accepting a bribe of rupees 50,000 from the ONGC contractor. He has now been acquitted by the Honorable Court while order dated 7/4/2021. It has been given understand by the concerned department that the CBI has not filed an appeal in the concerned court against the judgment of special CBI court. It is also observed that Sri Lochan was placed under suspension on account of detention by the CBI. As mentioned above, he was allowed to superannuate under suspension as a criminal case was pending against him in the court for trial, and nature of the criminal misconduct was such that in the event of adverse court judgment, the same could have been resulted in penalty, removal, dismissal of the service. To this extent, his initial and subsequent continued suspension was not fully justified. From the fact, my lord, this is very important, my lord, kindly see, from the fact and circumstances of the case, it is evident that though suspension of Sri Lochan was not wholly unjustified for the reasons mentioned above, yet his acquittal by the court also cannot be ignored while deciding the appeal. Now, what is the decision they have been, the CGM, the appellate authority given? In view of above, I am considered opinion that owing to his acquittal by the court, in case of which course of so-and-so, it would be interest of justice to invoke the clause so-and-so, bail and so-and-so, which state under. In other cases, employees shall be given such proportionate pay allowances as such competent authority may specify on behalf. Therefore, keeping on view the circumstances of the case, I am considered opinion that Sri Lochan be provided 95% of pay allowances due for the relevant period. His appeal considered period suspension. His appeal to consider period of suspension as a duty is not agreed. My lord, this is the finding, my lord. I am aggrieved, my lord. Now, when I have been acquitted, my lord, they have come with that, he is not been honorably acquitted, my lord. I have placed before the judgment of the Supreme Court also.
This is an order passed by whom? By the appellate authority.
Appellate authority. It is
Against what?
Against, my lord, the order by which is impugn order that is at page 33, my lord. I'm sorry, my lord. 22-9, there is an page 31 in my read petition of annexure 9, my lord.
31.
Last line, my lord, Your Lordship, kindly see. Considering the fact of the circumstance of the entire cases for the arrest of the acquittal, I am of the opinion that deemed suspension of so and its continuation till is not wholly unjustified. Therefore, the period of such a so cannot be treated the period of span on duty. The period is to be treated or not on duty. In case the individual desires, the period can be regularized by granting leave. However, if he doesn't want to do so, the period is to be treated as a dies. None, that is neither service nor break. In the service during the period, he is entitled only the substantial allowance already as per rules. His claim for full salary allowances or suspension period is not agreed. My lord.
Yes.
So, in nutshell, my lord, that is my case, my lord. When I have been acquitted of all charges, exonerated, my lord, why I'm not entitled to? Because had it been, my lord, there's a departmental procedure and find something against me, then okay, fine, I agree to that.
What is the provision of this regulation 12.3?
Is the Malat authority is 12P is the Malat empowered the authority to fix the pay and allowances as per this thing. Malat, what they said, Malat, it is kindly see what it says.
Where is 12.3?
12.3, Malat, is a pay and allowances regulation which stated at under, Malat. This is quote. And that's in kindly see that is in their affidavit, page 58, Malat. In other cases, my lord, the employee shall be given such proportion of pay and allowances as such competent authority may specify in this bill. What are you saying, my lord?
No, other cases means in what are the
Malat,
cases excluded from other cases?
Cases of suspension, Your Honor, but whereby when it comes that he has been acquitted in this case, Your Lordship. So even though he has been acquitted, Your Lordship, but the thing is that the criminal prosecution was not initiated by the department. It was initiated by some other person. So during that period of time, he was under suspension because that is as per the rules, Your Lordship. Now for that, when the suspension was, when he got acquitted, we regularized his service. But at the same time, the suspension was not wholly unjustified. So considering that factor, the pay and allowances will be determined by the authority department.
Under your rule, this suspension the punishment.
Your Lordship, suspension is there, Your Lordship.
I know it is there, but
Yes.
it is to be treated as a punishment.
Not a punishment. It's not a punishment, Lordship. But even though he is under suspension, then because he was suspension at the time of his service, Lordship, so that has to be calculated by the respondent's, Lordship.
That's right.
Yes,
So, suspension is not a punishment.
Lordship.
Why are you deducting his pay and allowance after getting revocation?
No, because Lordship, in this scenario, once he got suspended, because he was not,
Therefore, I am asking you repeatedly that
Lordship.
under your rule,
Lordship.
you think suspension to be a punishment,
No, suspension is not a punishment,
not
Lordship.
a punishment.
Yes, sir.
So it is a process by which the person is kept away from his office,
Lordship.
pending perhaps departmental procedure.
Lordship.
But you have not initiated departmental procedure.
Lordship.
An authority, I do not know what the rules say, but perhaps to arrive at a finding that this person not required to be given pay and allowance has to be arrived at by way of a process.
Lordship, because there's already a committee which has been initiating the suspension.
Quite right, but is it a part of the group? Is it reflected in your group?
Lordship, the rules of pay and conduct, pay and salary will have that, Lordship.
I
And-
don't know. It is for you to tell us.
Yes, Your Lordship, but I'm very sorry, Lordship, but I'm not carrying that rule
You're
right
not
now. with
caring
me.
that you should carry and make it
Lordship.
a part of the pleading. We
Lordship.
like to see your rule.
Lordship.
How you can revoke a person's suspension
Lordship.
and then without following a process,
Lordship.
if permitted under the discipline and appeal, your rule,
Lordship.
you decide that this man will not be given a part of his salary allowance.
Lordship.
What with
Lordship. Because, Lordship, the order was passed by the appellate authority.
may have
So-
been passed by anybody, but it
Yes.
must be in consonance with the rules framed by your authority.
Yes, Your Lordship.
So that is what has been quoted in the order
No,
also.
we don't want to see a quoting, we want to see the rules. Where are the rules?
Lordship, then may kindly fix the matter. I'll produce the rules for your lordship on the next date.
You should have had the route. Your affidavit does not make any reference to the relevant route. What is the process?
Lordship. I deeply apologize of that.
You have to tell us, show us that what are your rules, and
Lordship.
on what basis this amounts to a punishment that you are, what is it?
I will satisfy your lordship. With the
No,
rules.
no, you satisfy on what?
The rules, lordship, with regard to why the 95% has been brought in this picture and not 100% had not been given since the suspension was revoked. Lordship, that is as per
You
the
have
rules.
to satisfy that
Lordship.
whether this falls under punishment or not.
Lordship. I will satisfy. If lordship may give me a short date on this.
Even after filing an affidavit, you don't have the correct information.
They have not stated anything on this in their affidavit, below. And also they said that they say that although
You
they
don't
have
have a copy of the rules here.
That is what it's not here.
He is not here.
At this moment, it's not.
And you are appearing before the court trying to defend the organization without a set of rules.
I have the Code of Conduct Disciplinary Rule CDA, Lord, but the pay and allowances rule was
Under what provision this its impugned order was passed?
12(3), Your Lordship, of the pay and allowances.
12.3.
12(3), Lordship.
No, 12.3 is quoted there.
Yes, Your
It
Lordship.
page 58.
Lordship.
But from where does the officer get his source of power? Under what rules?
Yes, Your Lordship, because under the rules of Code of Conduct, Lordship, Lordship, at rule number,
You show us the rules. Let us have a look at the rules.
Rule 33, Lordship, with regard to suspension, which talks about the appointing authority or any other authority who has been
For what purpose? To
for
suspend.
any for any proceeding where a case has been instituted against a person or an employee, like in our scenario, Lordship, in this case where an FIR has been lodged. So when a person has to be brought into
No,
suspension,
no, that's what I'm asking. Merely
Yes.
because an FIR is lost, you suspend a person, or is it because of the disciplinary proceeding?
No, Lordship. Even if a case is registered
Let us
against a
see your
person,
rules.
Lordship.
Yes. Then what is the purpose of placing him under suspension?
Lordship, because he was because of the case being registered against him.
Then you are treating it to be a penalty.
We put him on a suspension, Lordship, and thereafter, when he was acquitted, Lordship, then we also revoked his
You
suspension.
revoked it, but you did not release his allowances. Why?
We released 95% of it, Lordship.
No, no, why? Why 5%?
Because of the clause of 12(3), Lordship.
No, no. Clause
Pay-
12.3 cannot be unilaterally invoked without following the procedure of Rule 34.
Lordship.
Your Rule 34 has to be followed.
Lordship, Rule 34 will apply only for when a major penalty or any kind of
It's a penalty.
yes,
It's a
if
penalty.
he was convicted, Lordship, then these penalties would
No,
True.
non-grant of a salary amount to a penalty. Rule 34, 36,
Lordship, but here in this case, since he was acquitted, Lordship. So there,
if he is acquitted, why
yes.
have you withhold this 5%?
Because of the provision of 12(3), Lordship.
What 12.3? Where is 12.3?
No, of the Pay and Allowances Act rules, Lordship.
No, but to withhold the pay, there must be a procedure.
Yes, your Lordship.
You are referring to the power for withholding a pay.
Lordship.
But can you withhold the pay merely because the power is there without following the procedure prescribed?
Lordship, because Lordship, that we cannot if it would have been in a scenario, he would have got convicted. But since he got acquitted, but the whole concept is that suspension is not unjustified.
You have not proceeded for a departmental proceeding. You
Lordship.
have not arrived at a finding that he is guilty.
Lordship.
It
Because
is not your case that FIR has been filed by you, appeal has been filed, nothing. The authority against the authority who proceeded against the competent authority before whom the case proceeded,
Lordship.
considered that evidence was not sufficient to discharge him. Now, where is the question of guilt?
Lordship, it's about there is the whole provision which is in the rules of pay. That
That is
when
what we are trying to make you understand,
Yes,
which
sir.
you are not helping yourself to understand and reflecting on the rules.
Lordship.
To arrive at a finding that this man is not entitled to he is entitled to his salary as per his appointment orders.
Like
Unless you want to drop a proceeding saying that because of X, Y, Z reason he is not entitled.
Lordship.
Now, what is your reason for withholding 5%?
That is what Lordship I'm trying to tell this court, that it is because of the provisions provided in the rules for grade of pay where we can withhold.
The question is not whether you can. The question is why have you withhold?
Because
Not
of the
because you have a
suspension.
power.
Because he was under suspension.
He was under suspension because you are not treating suspension to be a punishment.
No, Lordship.
Then, unless you treat it to be a punishment,
Lordship.
how can you penalize him? You penalize him for being under suspension.
Lordship.
He is not under suspension on his of his own choice. You have placed him under suspension.
Lordship, pay and allowances regulations give that provisions to us.
You are arguing on thin air. Where is your rule?
That's why, Lordship, I seek some time on that.
Yeah.
I'll satisfy this court.
Yes, tell us when you can get the rule.
Lordship, in a week.
Yes, Mr. Bora.
Well, let them, if he wants to give blood, it's very clear. Lordship, give time.
We need the rule. Yeah, either you produce or they produce.
My lord, the pay and allowances rules, what your lordship has said to it, number one, they have to fulfill the 34, the process that, have I been, my lord, have I been?
He wants to say that this power is inherent in that rule, but the rules are not here before the court.
Definitely, my lord.
So therefore,
Well,
give us a
your
date
lordship
or
may give the,
can fix it.
give the time, fix a date, my lord.
You tell us which date.
My lord, that is, your lordship will find, 25th or 26th,
25th or 26th
my lord.
of May.
No, April. So, only the rules has to be said, my lord, my lord, I'll place the judgment of the Supreme Court also that if it is there,
25th or all right, based on 25th April, by which date the respondent will produce the relevant, what is the rules?
Your Lordship, ONGC pay and allowances rules.
ONGC pay and allowances rules, which year?
Lordship, 1972.
1972, along with all other relevant rules for consideration of the matter. Yes, accordingly. Mr. P. Bora, Learned Senior Counsel, let's go by MS.
Yes, sir.
Yes, sir. IPS.
Deeply obliged.
You're Mr.
MK Das.
M.K. Das, ONGC.
Deeply obliged.
Made pleasure. Well, as per the last order, it appears that the respondent has not filed any affidavit.
Well, I need some time to file our opposition, my lord.
Yeah, that sometime is very difficult. You give us
Well,
1 week, 2
3
weeks,
3 weeks, my lord, 3 weeks.
3 weeks time. Should we give him 4 weeks?
Yes. So that
Mr. N.J. Katunia, Learned Standing Counsel, Secondary education, prays for further 4 weeks time to file affidavit. Mr.
R.
Goswami,
Goswami.
R. Prayer. Sir,
And that's already on behalf of five.
and the Chaudhary. Yes, yeah, have you filed your affidavit?
No, Lordship, we will also file with it.
Permitted for file your affidavit. Yes, the court.
Obliged, Lordship.
Of that. Lordship, sometime my signature leg and put no full Lordship.
Matter will be listed next week. Next week,
Much of it.
the request of learned counsel.
In this case, Lordship, I have sent the affidavit for vetting, Lordship.
It is submitted by Mr. K. Gogoi that the affidavit is under preparation, like it filed short. It prays for 2 weeks time,
Lordship.
within which the affidavit will be filed. Mr. S.
SD, madam.
Dev.
SD.
Dev. Learned counsel appears for the says paper to be listed again on 15th of
Lordship.
May.
Lordship.
15th.
Much obliged.
Yes, 34. Yes.
Lordship, here in this matter, Lordship, the Director of Higher Education has sought for some report from the principal of the college, Lordship. So I pray for 2 weeks time, Lordship.
This is Rafik Mashi.
Yes, Lordship.
Yes.
Wrong fixation of-
You verify and pass order.
Yes, Lordship, that can be done.
Verify and pass order. Who is to verify?
Lordship, the principal will verify and send it to the Director of Higher Education, Lordship.
Who appears for the principal?
Yep. No.
Notice is not issued. So this verification part, why is it taking so much time and why is the principal not doing anything about it? Are you saying that the principal is not under the control of the higher education department?
Lordship, it is under our
You
control.
cannot get this information from the principal.
Lordship, we have already asked for the information, Lordship, but no reply has been.
Then what will you do?
Lordship, so in that case, Lordship, let it come after 2 weeks. Let
Do you want to take dusty on the principal?
I can, Lord.
Yes. Although notices are issued in the matter, however, none represents the college principal.
Respondent number 6.
Respondent number 6. Accordingly, petitioner is permitted to take custody service on respondent number 6. Stop custody to be routed through the registry of the High Court. And thereafter, an affidavit of compliance by to the court. Meanwhile, the respondent are permitted to complete their And the enterprise report will be ready. Mr. P. Sharma appears for the accountant.
2 and 3.
Accountant. Next again on 17th May. 17th.
Highly obliged.
Much obliged.
My lord, we have sent for vetting lordship. So before responding one, lordship. We need 2 weeks time.
Lordship, we give a fixed date. then.
4 weeks further time granted the respondent. Their file. As per my other after 4 weeks,
3 weeks, your lordship.
Right.
Lordship, can it be a shorter date, your lordship?
we can fix it tomorrow, day after, next week.
Yes, lordship.
But the vetting activity has to be completed. Isn't it?
Obliged.
After 4 weeks.
In this case, my lord, neither the education nor the finance department responded yet. Finance department is main department, my lord, they have issued the impugn order. It is wrong fixation of the, for the post of SIF schools, my lord. That is the
Wrong fixation of
salary.
yes, any instructions?
The impugn order was passed by the finance department, my lord.
Oh, who's for the finance? Where is the impugn order?
Page 96, my lord.
96 start. Shortcut, my lord, I submitted before, my lord. The post of SIF schools, my lord, in earlier they were in the payment 2. Now, my lord, they have been upgraded to earlier in the payment 3. Now it is payment 2, my lord, upgraded. As a result, what happened, my lord? Both the grade pay and the pay band have been increased. The examples given in
There
the
is no fitment table.
there is difference. That's why, my lord.
There is no fitment table.
Fitment table is there, my lord. And how to place in the fitment table, that is the that they have not, my lord, given correct formula.
Yes, who's for the finance?
As a result, what happened, my lord? It has come with on my lord 1/1/2016. The if someone is appointed on 1/1/2016, his salary and the salary of the persons who were appointed earlier, they become the same salary, my lord. That cannot be. The
In
part,
spite of the enhancement.
yes, that is the technical problem.
I'll turn it off. Respondents are yet to complete their- Yeah.
The date may be given, my lord, unless
Particularly finance and elementary education are five to nine. Without further delay. Then the standing council item of present board of the OPC. The order be marked the office. District
Obliged.
after 4 weeks.
37, my lord. Now the claim of area salary is
Area has been released.
not released, my lord. It is, I, so far as my information is concerned, it is sent to the director. My lord,
Yes, Mr.
I'm praying for some more time, my lord.
See, he has more instructions than
In fact, I have also received instruction, my lord.
your clients don't seem to give you the instruction. Instead, they're giving him instruction.
Yes, my lord.
Huh? Strange phenomena. Mr. N.J. Khatuniya, learned standing counsel, is permitted further 3 week time.
কোনটো বাজি
I'm appearing for respondent number five.
Respondent number
Five.
five.
Here, my lord, I have received the instruction, my lord.
Met Your Lordship. The body have come with a very limited prayer, my lord. The petitioner is working as subject issue, my lord.
But rule is
Of that
issued in the matter, madam.
Beg your pardon, my lord.
Rule has been issued.
Rule issued. But my lord, the
Matter should be
petition
heard.
will be disposed of, my lord, because he was suffering from, my lord, severe heart attack several times. So he was absent from medical leave has taken, and my lord,
Affidavits,
some person.
pleadings exchange, no.
No, my lord, I have received the instruction, my lord. I will file it within 2 weeks, my lord.
You file it, then rule having been issued.
Yes, my
will
lord,
list
that
it
is
for
not
hearing.
correct. That is
Since
But
rule has been issued
long
by
time, my
order
lord.
dated 2009-2023, matter be listed for hearing in the month of June,
Can you fix a date, my lord?
in the month of May, on a date to be fixed by the registry. The respondents are permitted to file their affidavit. You can say matter be directed to be listed by the registry on
Leave rule nahi dukun medical lord.
21st.
21st of May, my lord.
21st of
All right. Para kita tu itu kan? Reply to itu. Medical liver aku naik dulu. Ini kalau tak. No, no. That principle aku naik.
Mr. Dag,
That the previous order dated 29/2, my lord, 24, if kindly be found. State information. Then your lordship has passed order on 7/3/20.
so what is to be done?
Your lordship has finally heard the matter. Only of,
Then we keep it for a hearing date, not today. Let us,
they brought some instructions, I think, my lord. I don't know about.
these are your instructions.
Yes, Lordship, this has been as per Lordship's
Is the
direction.
fact, my lord, the additional chief secretary, my lord, who was the state chief information commissioner, he got the benefit of the gratuity.
Lordship, thing is little different. If your Lordship allows, then we need to file an additional affidavit to bring this fact on record, Lordship.
Bring it,
Lordship.
but bring it without further delay.
Yes, Lordship.
Date may be fixed.
Yes. After 2 weeks, Lordship, and within this time, I will file affidavit. Lordship.
Lordship has heard the matter in like
16th May.
16.
Yes, yes,
Let
Lordship.
us have it on 16th May. 16 May. Is it all right for you, Mr. Das?
Can it be bit early, my lord, because your lordship will forget whatever what has been written on 29 to
9th, 9th of May.
9.
Yes, can be, Lordship.
Matter be listed on 9th of May. Meanwhile, the respondents are permitted to bring on record the instruction received by way of an additional affidavit. List.
Bless your Lordship.
It will come as admission hearing.
Admission here. Admission here.
We should understand that it will be heard finally.
Attempt will be made to dispose of the writ petition on the next day, on the next date fixed for the matter.
May it please your lordship. This is with regard to, my lord, recovery from the retirement benefit as well as, my lord, decision taken to reduce the last pay drawn, which will ultimately have the effect of reduction of his pension. After the retirement of the petitioner, the respondent has come up with a stand that at the time of his initial appointment in the year 1986, he should not have got one increment, which was given to him wrongly. And now, after more than 30 years, they want to make the recovery.
He was retired as what?
Sorry, my lord.
He worked as which
Registrar.
registrar?
Yes, my lord.
That increment was only one increment or
One increment. At the time of, actually, my lord,
what is the amount?
My lord, 500. Sorry, my lord, 20 rupees.
You are before the court seeking an order against 20 rupees.
No, my lord. What they wanted to do from 86 onwards, they will reduce in every pay commission, my lord. Annexure 5, if your lordships have a look, P5, page 29.
Yes.
Sorry, my lord, 60 rupees. I'm sorry. It says, in inviting reference to your letter dated so and so on subject cited above, I am state that on scrutiny of service book and pension papers of so and so register, it is found that initial pay of the incumbent, that is from the date of joining as 19,581, has been fixed at 560, which is found incorrect. As the initial pay started from minimum 500, as such, the pay of the incumbent is to be fixed at rupees 500 on 19,500. My lord, this should be 1981, my lord. Thereafter, annual increment will be granted from time to time. In view of above, I am constrained to return herewith the service book and pension paper in original with a request to resubmit the case after necessary correction of pay from the date of beginning of service to till the date of retirement, including correct fixation of pay as per ROP 89, 98, 10, 17, as well as annual increment in time to time, and same may be recorded in service book clearly with due attestation by the competent authority. The excess payment drawn by the incumbent from the date of beginning of service may please be incorporated in Form 19 with due drawn statement, and it should be attached along with the pension papers. A fresh LPC may also be furnished. So that they are trying to give effect to each pay revision as well as in calculating increment. And they have determined an amount they sought to recover, which is below impermissible in view of the Government of Assam OM.
So that is for grade 3 and 4. You're not a grade
No,
3 and 4.
retired persons are also included there, my lord.
But the amount, how have you managed to draw an excess amount of 10 lakhs?
It's there, my lord. They have calculated from 81.
At the rate of 60 rupees.
60 rupees. My lord, say for example, 560 will be revised to some amount. Say for example, my lord, 5,500. That they will reduce. They will correspond 500 to 5,000 in that manner, and they have given it in the effect in the increments also. I'll earn increment that affected that also. No, it is absolutely impermissible to make the recovery and change the last pay drawn. And one more thing, my lord, another person who was also along with me, no such correction has been made in his regard. He died, my lord. His wife is receiving family pension at the same rate that I have, at the same last pay that I am drawing, my lord. That also I have annexed. It is, his name is, my lord, Obani Kumar Busumotari. I have given the fixation memorandum of that time
But this is recovery to be made on the consent. You have not given your consent.
No.
Kindly read para 9 of the affidavit,
Para 9,
of the affidavit in opposition.
in case of such type of previous cases, recovery of excess amount is made on receipt of consent of recovery from the concerned retirees. The same procedure is initiated in case of petitioner also on receipt of consent from the petitioner. The matter will be intimated, my lord. I never give consent, my lord.
No, now what is the problem that you're facing? Other than the imminent threat of the amount being recovered.
That your lordships has protected, my lord. There is a stay order passed, my lord.
Right.
They are, the AG has to come up with some stand as of now.
Yes.
Twice, thrice, your lordships granted time, on one occasion, lordships has written also in the order that if you don't file, we'll proceed with the hearing.
I'm sorry, Your Lordship. In this case also, we have been recently, in fact, this, I am appearing for first time, Your Lordship.
No, last time Mr. Talukdar appeared.
Your Lordship.
No, this affidavit is filed by the state.
State.
Respondent number.
We have nothing to say so much about this.
Have you received a copy of this affidavit?
No, Lordship, I do not have the brief also right now. Yeah. Lordship may give me 2 weeks time, Your Lordship. I will come with the entire instruction, Your Lordship. I am appearing for first time, Your Lordship, in this case.
How will you get the brief?
I will collect them, collect it from the official.
Heard Mr. R.
R. Boro on behalf of C. Boro, Lordship. 3 and 4.
That he appears for counted and as been recently engaged in the real report of the representative. Therefore, that for the time submit that time he be granted some time to complete his instruction. Prayer made by the prayer made by the respondent is objected. Any objection?
No. I'll give the extra copy to my friend, my lord.
Again after 2 weeks.
3 weeks.
3 weeks.
Oblige, Your Lordship.
Lordship, may I pray for a date, my lord, if possible?
It's the matter on 3rd of June.
3rd of June.
Interim order.
After
Oblige, Your Lordship.
Deeply.
Yes, that's the problem.
Please, by the petitioner, apply for transfer from Odalgui to.
Lordship, on the last occasion, our names are reflected. We are again we are yet to receive our instruction. Some time may be given, my lord.
Because police have already received.
No, weeks
Give
time.
them some time.
Maybe 2 weeks, my lord.
2 weeks.
Mr. Ray Cooper, is planning to AD great for transit. It's the matter after the period of 2 weeks. It's on 26.
If you oblige.
Of May. 26 May.
May. If you oblige.
May it please your lordship, my lord. My lord, here this petitioner is retiring, my lord, by 30th of April 2024, my lord. He was placed under, my lord, suspension on 22/6/2023, lordship. After granting bail, bail was granted on 24/5/2023. My lord,
Yes, now
my lord, this suspension order, my lord, is at page 33, my lord.
33.
Yes. My lord, second para, my lord. Whereas the executive engineer White letter number so and so dated 3/6/2023, second para I was stating, my lord, has informed that Pulin Sekia, accounts officer, Bokakhat PHA division, was caught red-handed by the Vigilance and Anti-Corruption Department while accepting bribe on 12/4/2002 after office hour at Samuguri. He was under judicial custody since then till 24/4/2023 and granted bail on 25/5/2023 in ACB PS case number so and so. Now, my lord, this suspension order has been issued under sub rule 1, rule 6 of some service discipline and appeal manual. Now, lordship, after issuance of this suspension, pending suspension, the and now inquiry allegation page 37, they sought for conducting inquiry, my lord, under Rule 9, page 37, my lord, of Assam Service Disciplinary Appeal Rule 1964.
Hmm.
My lord, allegation, statement of allegation, page 37, last paragraph. While Pulin Sekia was performing his duties as accounts officer, office of the executive engineer Bukakar, he was caught red-handed by Vigilance Department while accepting bribe on rupees 50,000 for release of running bill of so and so. After office hours, he was under judicial custody since then till 24/4/2023 and was granted bail on 25/5/2023 in ACB PS case number so. My lord, my question is here, my lord, that from the date of suspension to the date of issuance of the, my lord, departmental inquiry, my lord, there is a gap of 107 days. My lord, if
You are suspended on
22/6/2023 and inquiry on intimated us, my lord, under Rule 9, 9/10/2023. It is after 108 days, my lord. If any suspension order, my lord, is issued.
when were you released on bail?
My lord, this is here, my 25/5/2023, page 33. My lord, order I have annexed, my lord, page 33 also, suspension order itself mentioned that, my lord. My lord, now my question is that, my lord, if within 90 days, if there is no review and DP is initiated after expiry of 90 days, my lord, then, my lord, suspension order
Will have to be examined whether such is the case that requires interference.
my lord, because here, my lord, he is retiring by 30th of April. And last order, my lord, therefore last order, kindly say, my lord, 21/3/2024 is a noting, my lord, 21/3/2020 second para, my
We
lord.
want to know
And therefore,
what is that judgment?
Lordship, kindly see page 53. Lord.
No, what is that judgment? of
yes,
the
my lord, I have placed as
single bench or division bench judgment
yes,
of our High Court
my lord.
that 90 days is not an arithmetical.
Exactly on that issue, Lordship. That issue in this case also, Lordship. In this particular case also, that issue was addressed by the Honorable Court, Lordship, page 53.
53.
Yes, Lordship. This is order dated 23/1/2024, passed in IA 3702/2023. The learned court, Lordship, after considering all these facts, Lordship, granted liberty to the department to review the case of the petitioner in response to his representation. Accordingly, department considered his representation and his suspension was extended. That extended order is at page 63. Now, this order is under challenge, Lord, page 63.
My lord, lordship kindly see a line in page 53, the order 23/1/2024. My lord, there, my lord, in the second paragraph, it is stated, however, the order of suspension of applicant requisition has not been reviewed till today. My lord, they have not.
You filed this IA in this writ petition?
No, this is another
Earlier.
repetition challenging the DP, my lord.
Okay.
In that DP where I challenge, my lord, there I have made a prayer in the IA. And since this has been stayed, I may be allowed to continue and the suspension order may be, my lord, kept in abeyance stayed. My lord, there, my lord, the order
But
was passed.
now, because of this order, they have reviewed.
No, my lord. Yes. So far review is concerned, if they could not initiate DP within 90 days, then they have to issue a review order extending the suspension.
They had not done it. Therefore, you had filed an IA. Pursuant to the IA, they have done it.
My lord, the pronouncement of this honorable court is like that, my lord. Now, within 90 days, if you are
No,
not
that's
initiated.
quite right. But you came before the court with an IA. You invited the court to pass an order that your suspension was not reviewed. So therefore, the court passed an order.
My lord, from that impugn order also, my lord, what was ground taken that 108 days, after 90 days, you have issued the DP. That is not nowhere mentioned in the impugn order. That aspect has not been considered by them, my lord.
I don't think there is an order of this court, at least one order,
My lord.
where it says that this is not of mathematical precision, that 90 days, 91st day suspension becomes illegal, not like that.
My lord, therefore, earlier also I placed the judgments, my lord. Just for a moment, my lord. Here is the same case, my lord. They also appeal before the
There are
division bench.
several cases, Mr. Das, several cases.
Because my anxiety is that, my lord, that he is retiring and in suspension, his matter will be infectious. My lord, Ajit Sunwal case, my lord.
Ajit Sunwal is there. Prior to that, there are other cases.
Yes, yes. AK Odhyapak case is also, I have referred, my lord. This is on the same that within 90 days, either you initiate DP.
Basis of the entire judgment is Ajay Chaudhary.
Yeah, also Chaudhary. That is
Binding
also.
up to para 22 of Ajay Chaudhary.
21, yes.
22.
My lord.
Read 22.
Yes. Or it is 21, my lord.
22.
So far.
Yes.
So far as the fact of the present case are concerned, the appellant has now been served with a search sheet, and therefore these direction may not be relevant to him any longer. However, if the appellant is so advised, may challenge his continued suspension in any manner known to him, known to law. To this action, the respondents will be subject to the judicial review. Now, my lord, yes, that is correct. Put the judgment to. There is one judgment, there's recently honorable.
No. We come to all your judgments. You explain the purport of para 22.
To understand that, my lord, there, whom I have annexed, my lord, whom. There, whom.
Para 22 only.
That's correct, my lord. If DP has been initiated within 90 days, because this has been understood.
No.
From para 21.
No. If DP was initiated within 90 days,
yes,
the directions in para 21 are irrelevant, would not have been issued.
My lord, yes.
So in this case, DP obviously was not initiated within 90 days.
My lord.
Therefore, para 21 direction. But while the matter was being heard, the charge sheet was issued.
My lord.
DP was initiated. Therefore, the court said these directions will not be applicable, leaving liberty to the petitioner challenge his extended suspension. Here is the case where you were under suspension. You come before the court asking for review of the suspension or passing orders that suspension is not reviewed. On your application, court passes an order directing them to review.
And that will not cure this defect because they could have said, my lord.
Then you have to explain constructive res judicata, why you did not plead that in the IA, why did you not plead that post 90 days suspension is illegal?
That was my case there, my lord.
That was your case, but the order
Yes.
passed was giving
And-
liberty.
And in fact, my
Did not
representation.
go in appeal against this IA. No appeal was filed.
No, my lord, by considering that, my lord, Rossip kindly see, my lord, page that once again, page 53
Hmm.
of the order, my lord. My lord, the purport of the order was that if, since you have not reviewed,
Hmm.
kindly see, my lord, second paragraph, applicant herein was placed under suspension order
Mr.
22-6,
Counsel, Mr. Counsel,
my lord.
see what happens is when you come to a court, you come with a particular set of seeking particular set of relief.
My
What was the relief sought for in your IA?
my lord.
What was the relief sought for in your IA?
My lord, in fact, I have challenged them on suspension order.
You have
And
challenged the
there was,
suspension order.
there was a application,
You have challenged the suspension through an IA.
my lord, yes,
All right. So one of your grounds for challenge must have been that beyond 90 days,
that is, yes,
a review, a suspension could not have been carried out.
my lord.
But that apparently was not answered by the court. Rather, the court decided the matter,
Right.
directing the respondent
Yes,
to pass orders on review, which was done. So your primary ground that beyond 90 days,
my lord,
suspension is bad,
bad,
was either not answered or deemed to be rejected,
my lord. No, not
against which
rejected.
you did not go in appeal.
Because, my lord, their instruction before the honorable court was that, my lord, this suspension order was not reviewed till issuance of DP. This was their argument. If that be so, and the specifics then taken in my representation at page 44. So therefore, the honorable court, my lord, directed to dispose of the representation.
That's right.
But now,
But liberty was not granted for you to challenge the suspension. Was it granted?
my lord, since this was rejected by the
It
impugn
is
order,
deemed to be rejected.
yes.
Your
So-
prayer for your prayer for interference of the suspension is deemed to be rejected by this order. You were not granted liberty.
My lord, had they taken this ground that we have not reviewed the suspension till issuance of DP,
We don't
and
know.
in the
We are
impugn
only,
order,
we are only going by the order passed by the court.
my lord,
Kindly see the second penultimate
yes,
para. Penultimate para.
yes.
Kindly read the para.
As such, and as agreed to by the learned
Exact.
council.
As agreed to
Yes,
by learned councils for both
Yes.
sides.
yes.
So this was a consent order.
To consider the representation, what I was stated, my lord,
We don't know
representation,
as agreed by the learned council.
to consider my representation, my lord. But to representation, I have taken specific ground.
To consider
Page
your
48,
to
just for
consider your representation
my lord.
and pass an order
Yes.
is a part of the entire prayers before the
That's-
court,
Yes,
including passing of orders for setting aside of the suspension.
my lord.
Now that
Or revocation of the
revocation of the suspension, but no specific orders have been passed.
That's correct.
So it is deemed to be rejected or
So,
not pressed.
my lord, just for a moment, page 48, my representation 30.
Hmm.
My lord, 30/11/2023, 48, second paragraph, my lord. This is the representation, last paragraph. It appears the chair's memo dated so-and-so was issued after 108 days issuance of the suspension order dated 22/6/2023. There is no review of suspension till issuance of the suspension order. Therefore, without review of suspension after 3 months of issuance of the order, suspension 22/6/2023, prior to issuance of the suspension is bad in law, law since it violates the office memorandum 4/2022. 20. This is their office memorandum. Now, my lord, my question is that, my lord,
We
page
can discuss
60.
it today or we can discuss it on some other day.
Because, my lord,
Two options.
there is, my lord, it will be infractious.
We'll dismiss it.
Page 20, my lord, just for a moment. No,
Yes.
page 20, 60. Their impugn order, my lord.
60.
Yes, this is the impugn order they passed.
You are entitled to challenge this order.
Yes.
Challenge this order.
I have. My lord, last para kindly see, my lord. What they say, about this. They have not starts about that after expiry of 90 days that we have issued the DP. Nothing like that. But page 60 last para, whereas the Pulin Zekia accounts officer under suspension of engineer PH division has been charged with gross misconduct, breach of trust, lack of integrity, and action unbecoming on the part of
Yes, your
responsible government
affidavits.
servant.
Affidavit has not yet been filed.
Are
Lordship.
you willing to file?
Lordship, if your lordship is willing to dispose of this matter or dismiss this matter, Lordship,
No,
then it
he
is
is,
not required.
he is
But
challenging.
my only submission
He
will
is
be-
challenging the subsequent order of extension also.
But Lordship will see his ground. His
Whatever his
ground
ground
is
may be.
still that 90 days period has already elapsed. That is why it could not have been extended. But Lordship, when the order in the IA was passed, these facts were before the honorable court that 90 days period has already elapsed. In
Therefore,
spite of that,
we want
Lordship.
to file any
Lordship,
counter,
fine.
then we can hear the matter,
Lord.
dispose it of.
Lord.
Yes. But it will have to be after 30th.
And
After 30th.
because it will be before that, before 30, kindly fix a date, because they were given ample opportunity.
No,
in this.
what difficulties will he face? We'll decide it after 30. He's retiring and when is he retiring?
38th of April,
Right. So from 1st of May, he's not getting his pension. It'll take some time for the paperwork to be completed. So we'll decide it on.
Kindly before 30th, any date.
It will be of no use, doctor.
No, because
Otherwise also it will be of no use.
All right, we'll put it on 2nd at your request. 2nd of May. Before 38, we can't.
Then, it will be interest otherwise,
Why?
Because, we could have understand, if they have taken the ground that we are not required to review, they have not, they are silent about that, They say that we are embarrassed of your action.
All right. We'll have it.
This
on
is after inquiry.
2020, because then they will not be, we cannot permit them to file their affidavit. We'll have to give them some time.
Yes, sir. Because by the last order also, they were given 3 weeks time. Lordship has given earlier 4 weeks time. So if or my lord may be pleased to call for the record on a particular date before my retirement.
Record for what?
Because whether for this period,
We are not convinced. We have given you enough indication. So what illegality do you find in this order?
because in the impugn order, they have not said, my lord, whether they are saying that we are not required to review.
No, I am not saying we are
No,
not required.
they
We are required to
already
review,
reviewed.
but 90 days will not be an issue now, Lordship, after passing that
that
order
is
in
the
IA.
case. Whether non-issuance of DP within 90 days will lapse the suspension order.
That is already covered. I've told you. If
My lord-
that is the ground, we'll take it away right away.
Look, these are the judgments that I want to place, my lord. There, my lord, it has been said that suspension, okay. But if you have not initiated the DP within 90 days, then you have to extend the suspension order. And they have earlier said that there is no order extending the
Under what-
suspension.
Under what provision?
Yes, my lord, the manual that one is.
Manual is not a rule. It is a means for guidance.
Yes, okay. But however, my lord, that some judgment has quoted 2.1.8 of the manual of departmental proceeding.
The problem is that you lay more stress on the paragraph. You don't read the judgment. You have not read Ajay Chaudhary. Have you read Ajay Chaudhary?
I have, my lord, but
What was the facts involved in the Ajay Chaudhary?
no, there, my lord, DP was given, initiated. But now, para 21 is the guideline.
DP was not initiated. Why is para 21 guideline necessary for Ajay Chaudhary?
My lord. My lord, another aspect, from their own, my
You
lord.
are starting the question of the board.
No, my lord, sorry.
We are asking you what are the facts in Ajay Chaudhary.
Yes.
So we are not asking you to read. We understood that you have read it. So tell us. Facts are very simple. He is put under suspension for years together. No
Right.
DP.
Yeah.
Because under these circumstances, the court said, no, these are the guidelines. Follow it. So notwithstanding these guidelines, in para 22, court said in that case, DP was in the meantime initiated. So these guidelines will not be applicable, giving them liberty to challenge the extended suspension, in whatever manner. Same is the case here. You are placed under suspension, 90 days go, DP is initiated, you challenge the DP along with an IA saying that suspension be set aside. Court said, as agreed to, allow them to extend the review. They review it.
Perhaps my case is covered by writ appeal 114/2022. I have given the order.
Ajit Sonwal.
Ajit Sonwal case.
Prior
Here
to that,
also,
there is a judgment. You may like to go through it.
and the latest one is the Binod Kumar Payeng. Latest one. Binod Kumar Payeng by Honorable Justice.
But these are all on the facts.
Yes.
It doesn't lay down a proposition of law contrary to Ajay Chaudhary.
Malo, here,
Cannot.
what does one paragraph for writ appeal from the writ appeal, Malo? Para 16.
We have seen it.
Mal.
We are trying to make you understand. You are a counsel. You have to answer the questions of the
That's
court.
correct. Yes.
You are refusing to answer the questions of the court.
Aye.
You come with multiple choices, A, B, C, D. And if we ask something in between A and B, you have no answer.
Well, my anxiety with the data.
Your anxiety can
Otherwise, I would not have
your
any
anxiety
problem.
is misplaced. Your anxiety is misplaced. If you answer the questions of the court, we'll grant you the relief. But your facts which you have pleaded before the court, prima facie, we don't find any merit in your matter.
No, only my argument was that, my lord, in the representation, what I have stated about the, my lord, suspension, and by the order of the honorable court, whereby the representative was directed to be disposed of, they have not disposed of with the intent and purport of the order passed in this IA, my lord. Because I have categorically stated, look, that you have issued the DP after 90 days. This is my
Your direction
ground.
in the IA was the disposal.
Disposal.
That's right.
And
You
disposal is wrong, my lord. This is my.
That will examine it. Can't be done before 30. That's what we are saying. List the matter in the month of May, in the week beginning from 20 to 0, by which time the respondent will file their necessary affidavits in the matter. We'll hear it on that, only on that limited issue. In any case, after 38, it becomes infructuous.
Therefore, my lord, before 30, any date, kindly, let them have that whatever instruction, whatever
No.
they want to, because they have got
No, Mr.
time.
Counsel,
Yes.
you understood the query of the court, did not understand it correctly. What becomes infructuous is the position of being suspended. What does not become infructuous are your claims during the period of suspension.
Yes.
Then, if the order of suspension has been held to be wrongly passed, then you will be directed to be reinstated in service with all back wages, everything. That is still a live issue. We'll decide on that.
I hope Lordship may fix a date, my lord.
All right, let the matter be listed again on 28th of May. 28th. By which time the respondents will file the necessary affidavit.
As per the earlier observation, Lordship may observe, my lord, this endeavor may be made.
Endeavor will be made to dispose of the writ petition in the meantime. On the
On
next date, if no affidavit is filed by the respondents.
Problem.
Lordship, Assam State Agricultural Marketing Board is a necessary party. Their names are not reflected in the cost list. Therefore, last order, Lordship, it was reflected.
So there's no be appeared.
Notice of motion to be appeared.
Then we need to wait for what?
Wait, service.
await service. So, but has anyone accepted notice?
We are supposed to take,
Okay. They submitted that matter pertains to
name of sending council be
Assam
reflected
State
in the call
Agriculture
list.
Marketing Board, which notice has already been issued, and Mr. N.J. Gogoi, standing
No.
counsel.
Petitioner to serve notice to the, we have served to NJ Gogoi. So his name is not there.
However, the matter having been called up to the standing council marketing board, let the matter be listed next week, reflecting the name of the all the standing council.
NJ Gogoi. NJ Gogoi.
Yes. Listed.
I was told the copy has been provided.
You have taken steps.
Yes, to him. Obliged.
Right, here, my lord. Service is complete, my lord. It is supposed to, my lord, listed for admission column.
It is submitted that services in the matter are completed accordingly. Matter be listed for admission after 1 week. After 1 week,
I paid for a date, my lord.
if you come after 1 week, you can have everything on dates. What is the matter about?
It's, my lord, for pensionary benefit matter.
Pensionary benefit. Let it be on 13. 13 May.
This matter pertains to non-payment of my pensionary benefit. I was retired from service on 28 February 2020.
Some affidavit has been required to be filed, not
Yes.
received.
As per last order 1310.
Who is supposed to file the affidavit? School education.
Yes, my lord.
What has happened
No, we have not filed.
and why?
It was indicated in the order date 1310, my lord, that they have received the instruction.
What are your instructions?
I have not been even provided my provisional pay.
You are superannuated while under suspension. And why the pension has not been released? And what order has been passed in the criminal
No order has
revision?
been passed, my lord.
In the criminal revision, what has been passed?
Criminally, I was convicted, my lord, by the trial court and then appellate court. That conviction was affirmed, and we have filed a revision before this court that is pending, and there is a stay of the judgment. And the conviction was suspended. This for this somewhere listed in the part 2.
Yes, Mr. Adonier.
Though, my lord, as my learned friend said that on last occasion, someone has appeared and said an instruction has been received. Today, I don't have that instruction, my lord. Now I'm paying for 1 week time, my lord, so that
Mr. N.J. Khatunier prays for and is granted 2 weeks' time to complete his instructions and file necessary affidavit to it. The learned counsel for the petitioner submits that his pensionary benefits have not been released on the pretext that a criminal revision petition filed by the petitioner is pending before the court, challenging his conviction. Mr. R. Boro appears for accountant general. Is it R. Boro? Yes. Please, after 2 weeks.
For admission, my lord, because
For admission.
notice of reasoning.
service has been completed.
For admission.
May I pray for a date?
13th
Problem.
May.
Lordship, in this matter, we have already filed our affidavit, Lordship. We have annexed the project one proposal. Yes,
You have filed affidavit.
Lordship.
Is it for all this? Yes, you want to file a reply or something? No? Is there in the affidavit?
In the affidavit, I admitted, my lord.
They admitted.
Yes.
That amount is to be paid.
Yes.
I believe we had passed similar orders disposing of matters.
Yes, Lordship. Earlier, there were other matters that were tagged along. Those matters have been disposed properly.
So what orders have been passed there?
My lord, during the petition period, my lord, they already paid the full amount of the petition.
In your case, it has not been paid.
And in my case also pending, paid my lord, this 3 matters only not paid.
That's what in this rate petition.
Yes.
What is the status here? Where is that paragraph admitting? Where is that paragraph?
Paragraph 7, Lordship.
Paragraph 7.
Of the affidavit filed by respondent number 4 on 4/4/2024.
Merely saying that there is lack of sufficient source is not going to absolve you of your responsibilities. Yes.
We have already sent a budget proposal. Lordship.
You have already?
Sent a budget proposal. Lordship.
Ah.
So in that proposal, the name of the petitioners are shown on page number 76, Lordship, Annex 1. In the last second paragraph.
You are appearing on whose behalf?
Respondent number 4, corporation, Lordship.
Corporation. That's what we are saying. And who's for the department? To whom have you sent the proposal?
To the tribal affairs.
Yes, tribal affair.
My lord, the corporation, if you go by, my lord, by the
No, but you have,
procedure, my lord,
you have earlier,
my lord, last 23, 24, my lord, we have given them
why is
9.26
the
crore.
corporation not put up? If it is defunct, why is it not put up? Should wind up.
We cannot wind up, my lord.
Who will? You are the administrative authority.
No, my lord. We just give them granting it, my lord. Corporation is on their own. We just give them granting aid. Last, we have given them 9.26 crore, my lord.
You are representing which?
My lord, tribal affairs.
Tribal.
My lord, but still I have an instruction, my lord, that I am placing before your lordship. They have some good news, but they have to move. That is the thing. This year even, again, in this budget, 24-25, 5.64 crore. We are giving them a grant in it to meet up this area salaries and all, my lord. So now we have written to them even to move the proposal again. This I'm just placing before lordship. So they have to now move to us.
So they have already moved the proposal 5.9 something. Isn't it?
5.6 crore, my lord. The second page, we have written to the MD, the second page.
No, but that's only
5.64
crores,
crore.
64 lakhs.
No, that is, my lord, 5.64 crore.
Huh?
564 lakhs, my lord. That is 5 crore 64 lakhs.
That's right. Their requirement is
Ma-
59 crores.
Not 59 crore, my lord.
Yes, there's 75.
My lord, we have already given them 9.26 crore just few months back. They have moved for 9.28 crore, my lord. In the first page, my lord, my lord will find regarding proposal contingency, they have moved that CF, my lord, for 928.
No, we don't know the total amount they say is
My lord,
59 crores.
that is their budget till 2030.
Huh. But only for salary.
Only for the area salary, my lord.
Area salary, gratuity, leave encashment.
My lord.
That comes.
My lord, the thing is that if we go by the law even, my lord, we are not, my lord, not burdened with this, my lord.
No.
But still we are trying to, my lord, accommodate them, my lord. We are giving them this. Now at least let them move it, my lord.
Move where?
They have to move to the department with this proposal that this have been this 5.62 crore that has been allocated, my lord, for them. So now they have to move, then this will go to finance and finance will give a vetting, my lord, then only concurrence, then only it will come.
Yes.
So they have to move, my lord, now. Let them take instruction. I am just giving them a.
Lordship may give us some time.
Sometime, yes, but these instructions must be brought up before the court. Otherwise, merely listing matters and giving you time for instructions doesn't sort out.
itu instruction to already malo kumne pura hai ha 5.64
These instruction, these communications are not sent to the.
Yes, my lord, the second page is directly written to the
It's
MD.
already been sent.
Already been sent, my lord. And it's in, my lord,
9/4.
9/4 electronically signed, so it will immediately it will go, my lord, in the file.
You are not updated.
No, we have not received any instruction from the court.
You have not received instructions, means they have not given you instructions.
Lordship may give us some time, we will obtain instructions.
Let them seek, my lord. If they have moved, my lord, then
Standing counsel for the corporation prays for further time to complete its instructions, says Mr. Radhor, the governor, appearing for the Department of Tribal Affairs, bracket claims is food, submits that budget allocation for the year 2024-25 have an amount of rupees 564.00 lakhs. Within bracket 5 crore 64 lakhs has been allocated for payment of arrear salaries and retirement benefits. The former employees and real heirs of the deceased employee, as well as area salary service employees of APTDC Limited. So, the council of the department submits that the corporation is now required to take appropriate steps for sanctioning the amount for which the budget allocation is made. Mr. Suendra Learned Counsel for the APTC prays for further time to complete his instructions, list accordingly after 3 weeks. MSD Sonwal appears for the writ petition.
If I appear on the rest, item number 50 and 51,
50,
50 and 51.
50 and 51. And who appears in 49? Sir A. For 49. 50 and 51. MSD.
Lordship, in item number 50, our names are shown, but then we are not a necessary party in fact. Item number.
Let it remain. You become necessary for the time being. Until the next date. Yes.
Much okay.
Kindly peruse the order dated 15/5/2023, madam. In the relevant part, my lord, at paragraph 5. Despite this direction, my lord, neither the provisional pension nor the final pension has been given to the petitioner.
Yes.
Provisional pension.
I have received my instruction, my lord. As regards provisional pension, I have no instruction, but pairwise comment I have received, my lord.
Specific direction is there.
There is a direction.
Specific
Provisional pension, my lord.
Yes, you file your affidavit.
Yes.
And in deference to the order dated 15/5/2023, no order has been passed by the department as yet for release of provisional pension to the petitioner. Mr. N.J. Katonia, the planning council, I was that received this instruction. But with regard to release of provisional pension, he has no instruction. So accordingly, the respondent department are directed, are permitted to comply with the directions of the order of this court dated 15/5/2023 for release of provisional pension to the petitioner within a further period of 30 days from the date of receipt of a certified copy of this order. Stop. If these orders are not complied with, consequential orders will be considered to be passed by the court by the next date fixed. Meanwhile, the respondents are permitted to file their counter affidavit if so advised in the meantime. List accordingly after 4 weeks.
It may be
13.
May, madam.
Will it be 4 weeks?
No, my 13 May will not be 4 weeks.
24.
24.
24.
I think it's no more gonna affect on that.
May I please, Your Lordship, the review of order dated Lordship 1/9/2023 passed by Lordship, whereby Lordship has directed to give employment to the petitioner Lordship. Lordship, what has happened Lordship? Government of Nagaland had filed an affidavit and the matter relating to fake driving license. Lordship, they filed the affidavit and said this was a genuine license, but Lordship kindly see annexure B, page 49.
Okay, we'll issue notice.
Lordship.
Issue notice, returnable 4 weeks. Mr. None appears, na?
Lordship, notice.
Respondents will take steps, sorry, petitioner will take steps on the respondent by registered post as well as by written force within 1 week from today.
Lordship, in the meantime, Lordship, order may be stayed, Lordship. Otherwise, Lordship, kindly see page 49, Lordship.
49.
49.
What is the internal page of the order?
Internal page of the
No,
order is
which, you want to rely on which paragraph?
page 49, Lordship.
49.
That validity of the driving license, which was given by the government of Nagaland. With reference to your letter number so dated so on the subject cited, I have no.
No, what was the direction given by the court?
Lordship, direction was given in Lordship.
You consider, you've been asked to consider.
Lordship.
That's all.
That's
If
order.
you've considered, have you passed an order?
No, Lord.
Then
Right.
Your Lordship, okay, there's an IA, but no IA copy has been served to us.
Why not?
As per no, my lord.
Copy has been served to the finance department and government.
For
by-
amendment?
For
What do you want to amend?
Yeah, I is filed for amendment.
For amendment to what?
Amendment of the prayer was, it was not addressed in the prayer properly. The order, the impugned order was not addressed properly. So,
Is there any interim order in the writ petition?
No.
No.
So you withdraw and file
Yes,
afresh
yes.
instead of filing.
Amendment may be allowed.
We can allow your amendment, but then you'll have to file an amended petition.
Yes.
Then instead of that, if there is no interim order available, you
Only,
withdraw and file it afresh.
Yes, my lord.
Mainly the prayer is amended mostly.
Proceed.
Or not
Whatever it
many
may be.
prayers are added there.
My lord, prayer cannot be amended by filing an IA. They have to withdraw and file a fresh.
No, it can be amended.
Prayer
Any
cannot
stage
be.
of the prayer.
The amendment is okay, but this is not a suit.
Yes.
You're filing a writ. So therefore, notwithstanding that, it will be for the convenience of the court as well as for the council to have a consolidated set of pleading. If there is no interim order, you withdraw and file afresh whatever changes you want. We'll give it liberty.
It will be more simplified, my lord, if you allow.
No, it is not simplified. Because now you'll have to file an amended petition. Serve copies.
We'll do that. If you allow, we'll do that.
So makes things a little more complicated. Therefore, I'm asking you repeatedly, is there any interim order? If there is no interim order,
No interim.
No interim.
If it is allowed, we will prefer the amendment only, my lord.
then we issue notice.
Also,
Issue
the copy
notice.
has been served to us, the IA copy.
All right, we are issuing notice, returnable 4 weeks. We'll issue
Right.
notice.
Copy may be
all
served.
MS MD Bora, that is Setting Council,
WMD department.
WMD department, here, and submit no copy has been served on her. Yes, A Talukdar appears for
Government
For?
For government budget. 1, 9.
Respondent.
Respond number 9 and 1.
9 and
1 budget.
1 and 9.
Respondent number
1 and 9. Here's the respondent. The applicant serve copy on the respondent council, and the respondents are at liberty to file their own. It's after 4 weeks.
Deeply obliged.
also.
I filed for withdrawal of the affidavit in opposition, which is wrongly filed on behalf of one and
My lord, I
six.
pray for 2 weeks time to file our reply.
Is it permissible?
Yes, my lord, because the affidavit is swear by the Assam Rifle, but as for number 6 is CRPF. My lord. The content is same, my lord, but
Yeah, you let them file. Hard learning council. MS
T. Wapangla,
T. Wapangla appears for the
petitioner.
petitioner, the respondent. The respondents are permitted to file their affidavits, objections in the meantime. List after 4 weeks.
Interim may be conveyed.
Huh?
Interim still,
There's an interim order
my lord.
in the writ petition.
Writ.
In the writ petition, you write interim order passed earlier. We continue the next date fixed. Accordingly, matter be listed on 20 May.
Okay.
Lordship, here I have received instruction, Lordship. I may be allowed to file my affidavit.
None appears for the petitioner on board. You that's submit that you will instruct right.
Highly obliged.